Are you ready to make the most of your oil and gas mineral rights? Welcome to the Mineral Rights Podcast. Get the knowledge and resources you need to manage your minerals and royalties. Here is your host, Matt Sands.
Welcome to the Mineral Rights Podcast. Thank you so much for joining us. My name is Matt Sands, and I'm here to help you make the most of your mineral rights and royalties. Justin Williams joins me again to provide the individual mineral owner perspective. Good morning, Justin.
Good morning, Matt. Thanks for having me.
And today we're going to talk about the latest mineral rights news for March 2019. And before we get to the show, I have a quick reminder. Please subscribe to the show on iTunes or wherever you get your podcasts, and please leave us an honest rating and review. We read every one of them, and we do sincerely appreciate any feedback you have. And if you want to ask a question to be featured on an upcoming episode, please leave a comment at mineralrightspodcast.com or send an email to feedback@mineralrightspodcast.com. And I'll go ahead and dive into the first one. And Justin, this one is hot off the press. This was an article that I saw just from a couple of days ago in the Greeley Tribune, and about Colorado again and oil and gas regulation changes. So Republicans and industry groups are urging Democratic lawmakers in Colorado to wait just a minute when it comes to newly introduced sweeping oil and gas regulations bill scheduled for a hearing Tuesday. But bill sponsor and Senate Majority Leader Steve Fenberg is calling the industry and Republican hand-wringing nothing more than a political stunt. Senate Bill 19-181 was introduced about 5 p.m. Friday, a day after a joint news conference involving sponsors Fenberg, Speaker of the House Casey Becker, and Governor Jared Polis, among others. The bill would make a variety of changes to oil and gas law in Colorado, including the following. It would change the mission of the Colorado Oil and Gas Conservation Commission from one of fostering oil and gas development to one regulating the industry. It also changes the makeup of the COGCC board. It would provide explicit local control on oil and gas development, opening the door for local government-instituted bans or moratoriums, which have previously been tied up in court battles because the industry has been considered one of state interest. And it would change the way forced or statutory pooling works, requiring a higher threshold of obtained mineral rights before companies can force pool other mineral rights owners in an area. And this bill is set for a hearing at 2 p.m. Tuesday at the Colorado Senate, and in news releases sent Sunday afternoon, the Colorado Oil and Gas Association, the Colorado Petroleum Council, and the Colorado Republican Party all shared the same basic message. This is going too darn fast. We are asking that Senate President Garcia and others allow for a transparent stakeholder process that includes impacted Coloradans, including local governments, environmental interests, regulators, and industry, CPC Executive Director Tracy Bentley and KOGA President Dan Haley said in a joint news release Sunday. Colorado Republicans echoed these sentiments, albeit with a more political edge when addressing the schedule for the bill. They said, "This wasn't a mistake. It's a planned attempt to get this bill through the legislature as quickly as possible and prevent working Coloradans from speaking up," Colorado Republican Committee Chairman Jeff Hayes said in a release. So, Justin, what are your thoughts on this article?
I mean, it certainly sounds like they're trying to move this fast and try to ramrod this through as fast as they possibly can. And it doesn't sound like it's going to have a really great impact on the oil and gas industry in Colorado.
Yeah, I think you're exactly right. I think that, there's a couple of things in here. Just let me talk first from like the mineral rights point of view. Changes to forced or statutory pooling to the extent that they help protect individual mineral owners, I think is a good thing. I think they were talking about increasing this statutory royalty from 12.5% to 15%, which is a good thing. Right now, you don't have to have a majority of minerals leased before you can force pool other mineral owners. And I believe this proposed legislation would require 50% of mineral owners under lease before you can force pool the remaining owners. And so, I kind of go back and forth on that. I do think that on the downside, if you're a mineral owner that has leased or that does want to have your minerals developed so you can receive royalties, there's a chance that you could have holdouts. You could have people that maybe for whatever reason don't want minerals to be developed for environmental reasons or whatever. then they can hold everyone else hostage. So that to me could be a dicey situation. But probably the bigger thing is the local control on oil and gas development and the change of the mission to the COGCC is bad. I think that they're talking about removing engineers and geologists from the COGCC board. The analogy here to me is like it's like not having doctors on the medical board. So it doesn't make any sense to me that the folks that have the technical know-how they're not going to be on the board anymore, and that you'd only have one industry representative on the board, and the rest would be appointees, basically political appointees, which could be a dangerous situation on both sides. And then the other side is with local control. I think there's a good chance that a lot of what we've seen is local municipalities that if they're going to be tasked with controlling oil and gas or regulating oil and gas development, they just frankly don't have the technical know-how nor the resources to effectively do that. I think that it's going to put a financial burden on local governments, some of which want to take that on because they're just going to effectively put a moratorium in place to ban oil and gas development. Others that do want to work with industry are just going to be over their heads, I think, and having to figure out all this on their own. And so I think it is a much more effective situation to have at a state level regulating oil and gas, and then having a seat at the table for local government when it comes to specific COGCC orders. Then that to me makes more sense. But this is again, I think we go back to there being democratically controlled state legislature here in Colorado, and they're now exercising that muscle and trying to more strictly regulate industrial activities. So more to come. This does feel like they're trying to ramrod it through. I agree with you, Justin. And this is literally hot off the press. Friday. This is March 5th. And we're recording this. Last Friday, this was introduced, and today the hearing is going on. So it'll be really interesting to see how that goes, and hopefully there's more of a measured pace when they go to implement this, so it's not just a knee-jerk reaction.
Absolutely. It'll definitely be interesting to keep our eye on and see where it goes here.
All right, what you got next?
All right, so the next story we got here is out of Idaho. A 2017 lawsuit challenging Idaho gas and oil regulator's standard for approving forced pooling of mineral rights hasn't had any impact on operations while the litigation has proceeded, says the state's regulatory chief for oil and gas. Mick Thomas, administrator of the Oil and Gas Division at the Idaho Department of Lands, offered that assessment in a response to a question at a February 7th town hall meeting on oil and gas in Payette County Courthouse. On February 1st, the U.S. District Court Judge B. Lynn Windmill denied a motion from the state of Idaho to revise Windmill's ruling last August, requiring the state to vacate an integration forced pooling order in Fruitland. Before it could issue a new integration order, the state would have to hold a new hearing with clear criteria for determining whether the terms were fair to non-consenting mineral right owners. And what's your take on this, Matt? It sounds like it's kind of something that's been going back and forth here.
Yeah, this one, I guess, has been out there for a couple of years. And, I think it goes back to mineral owners that don't have a seat at the table, or maybe they felt like they were taken advantage of. I think it was in this particular case, you had an operator, and then you had some other interested parties. And at the end of the day, the compensation was not deemed to be enough. And so that, I think, is kind of what stemmed this, the lawsuit, and then the ruling to go back to the table to have a new hearing to determine whether non-consenting mineral rights owners were fairly compensated. And so I think there must have been some ambiguity, or there is some ambiguity in the Idaho regulations that don't allow for this process to happen beforehand. But in any case, it sounds like there's an opportunity there for them to set a precedence. And so I think this is probably where the interesting part of this article is really the precedence to come up with a new statutory pooling order, or they call it integration order in Idaho. That it'll be interesting to see what kind of criteria they set. So it could be a
Absolutely. Well, and I think those precedents are in mineral right owners' best interest because, throughout this process, I'm sure that there's a group of people who their lands haven't been able to be developed like they wish they had. and they're not receiving the royalties they could be receiving, so on and so forth.
Yeah, and I think it's, at the end of the day, this kind of interesting bit around forced pooling, and just thought of this. Sorry to chime in at the end, but the forced pooling is such a hot topic. We had that last article in Colorado talking about needing to change the forced pooling regulations, and then now in Idaho. So not just in Colorado where this is an issue, obviously in Idaho and in other states where there are forced pooling statutes or statutory pooling statutes. I think that there is an opportunity to update them to current lease rates and to fairly compensate mineral owners. I think that's probably the bigger issue here. All right. So what's the next article about?
All right, our next one here. Attorneys who represent landowners are raising concerns about an energy bill that sailed through the North Dakota Senate, with one calling it a wolf in sheep's clothing that takes away private property rights. And this is really a pretty interesting thing here that we were chatting about before the show. Senate Bill 2344 follows a study that found it may be economically viable to temporarily store natural gas underground as an alternative to flaring. Supporters of the bill say it removes uncertainty related to mineral developers' abilities to use pore space or the cavity or void underground where gas could be injected and temporarily stored. But Steve Easton, an attorney who represented landowners in the case upheld by the North Dakota Supreme Court, said oil and gas companies already have the right to use pore space and the bill is not needed. The bill would take away the option for compensation for landowners. Ownership of the pore space belongs to the surface owner, not the mineral owner. In addition to gas storage, the bill also has implications for underground storage of carbon dioxide, enhanced oil recovery operations, and saltwater disposal wells. This is the oil and gas industry saying we would have the ability to take property rights of a farmer and rancher in North Dakota out without even paying for them, said Easton, who served as a U.S. attorney for the District Court of North Dakota in the early 1990s. The bill also adds a definition of land, specifying the land means the solid material of earth regardless of ingredients, but excludes the pore space. Easton said the words, but excludes pore space, seems innocuous, but is a major shift in North Dakota law. A bill like this can be sort of a wolf in sheep's clothing, Easton said. People need to be aware of what's happening. The bill is a response to the North Dakota Supreme Court decision in the Mosser versus Denbury Resources case, in which the court upheld that Denbury had the right to use the rancher's pore space for the operation of a saltwater disposal well, but the company had to pay for the use. Easton, who represented the Mossers, said the bill will change that law.
Yeah, this is interesting because the thought that the pore space itself it belongs to the surface owner and not the mineral owner seems to go against what I would have thought. So I think that is kind of where Easton is coming in, and with the landowners. And I think all these articles somehow or another boil down to making sure that people are getting compensated fairly for whatever it is that they own. So if you're the surface owner or if you're the mineral owner, and to me, I think it probably boils down to a money situation. But talking about precedents is like the previous article. This one is setting an interesting precedent around the definition of land and who owns what. And so I think this is an interesting article from that standpoint. It wasn't something that I really would have thought of, that the surface owner owns the pore space.
Right. It seems kind of illogical when you're really thinking about it. And we had a nice giggle that the bill is specifying that the land means the solid material of earth, regardless of ingredients, but excludes pore space. And I think that's just, it's a little bit against common sense for most people, I think.
Yeah, I agree. I think so. All righty. Well, I think more to come there. Obviously, that one is in process, but it'll be interesting to see where that ends up. And on the flip side, I think it is a good thing that if you are able to limit flaring, from an environmental point of view, it's good. And plus, it's just wasteful. And so, to the extent they can store the gas underground and then capture it later, it's a good thing. It's just a matter of, is it done in a way that is compensating everybody in a fair manner? More to come there. Be interesting to see how that one goes as well.
Absolutely. No, it definitely will be interesting to see it shake out. And like you said, I mean, it's great for mineral right owners as well, because anything that's flared off, you're losing that opportunity to make the money from that. So like you're saying, if they can store that underground and then recover it, that would be great. But they've just got to figure out the economics of how everybody's going to get paid in that situation.
All right. Well, that wraps it up. So we have news articles we're going to be reading every month in between our regularly published episodes. So stay tuned for more to come. And if you do hear this and you're in Colorado and you're a mineral owner, write to your state legislature. There is definitely an opportunity to make sure that our voices are being heard as to how this will impact us. And I think that it's in best interest of mineral owners to ensure that the industry has a fair playing field to develop minerals, because obviously we're not going to get compensated unless we have the minerals that we've either inherited or invested in, or whatever your position is on and how you've gotten there. You're not going to get the return on that investment until oil and gas is produced. So write your legislators and let them know how you feel.
Absolutely. And I think, to your effect, and historically we've seen that highly regulated areas, the oil and gas companies, they just don't put the energy and effort into developing those areas. And like you were saying, really, I think the main thing going on there is them changing the structure of the Oil and Gas Commission to not being one who is trying to lead the development of the oil and gas, but rather that is regulating the industry. The oil and gas companies certainly won't take kindly to that.
All right. Well, thanks again for tuning in, and let us know again what you think. If you have any articles that you come across, please send them to feedback@mineralrightspodcast.com. And as always, please leave us an honest rating and review on iTunes or wherever you get your podcasts. We've had a couple lately, and that is definitely helping us get the word out. And so please continue to do that, and we'll feature your review on an upcoming episode. Thanks again, and we will talk to you next time.
Thanks so much for listening to the Mineral Rights Podcast with your host, Matt Sands. Don't forget to subscribe and share at mineralrightspodcast.com. The Mineral Rights Podcast should not be construed as investment, legal, or tax advice. All information is believed to be from reliable sources. However, we make no representation as to its completeness or accuracy.